With Donald Trump headed back to the White House, what happens to the criminal cases? Former federal prosecutor Harry Litman is here to discuss. Welcome back to Defending Democracy. I'm Marc Elias. Let's get started. Harry Litman, welcome to Defending Democracy.
Thanks, Mark. Good to be here.
All right. So I've been getting a ton of questions about what the hell is going on with the criminal cases involving Donald Trump. And boy, did I pick the right day and the right person to talk to. So we're going to go through all of them. We're going to talk state. We're going to talk federal. We're going to talk DC. We're going to talk Florida. So Harry, lead me wherever you think we should start.
All right. Well, to begin at the beginning. No, actually, why don't we begin at the end, Mark? Because today, I'm sure a number of your questions, I've gotten a whole flurry of them, has to do with these two motions that Jack Smith has filed in the federal cases. So he has moved to dismiss both the January 6th case in front of Judge Chutkan and the Mar-a-Lago case. Say it again?
In Washington, D.C.
In Washington, D.C. District Court. And the Mar-a-Lago case filed in the District Court in Florida, but now before the 11th Circuit on appeal from Judge Cannon's dismissal of it. I'll get back to that in a minute, and it's got some complications. So Smith, he was looking, of course, at walking before they make him run, and the assurance that the cases would be absolutely mothballed at best as soon as Trump's attorney general, whoever she or he might be, took the reins and he ordered it. So Smith's motion was not unexpected, but a really important point was at the end. Well, first, he says, we believe in this case. It's solid. We haven't changed our views, but we have this exceptional circumstance. No kidding. That the criminal defendant has been now elected president of the United States. And he goes in great length into, you remember this, OLC memo that Bob Mueller relied on way back in 2016 to say you can't indict and prosecute a sitting president. Now, there's going to be an opinion here, Mark, and it's going to be from the judge who has shown herself to be sympathetic to the case, not sympathetic to Trump. So I think it will be to Trump's chagrin that you're going to have an opinion reciting they still think the case is strong. It's got nothing to do with the case. It's got to do with this crazy concatenation of circumstances that he's going to be president. And most importantly, and we'll see if this can be reversed, if Trump has any ways to get at this, he has moved the court to dismiss without prejudice, that your sophisticated listeners probably know means you can bring it back up sometime if you want. I'll get back to that in a minute. But Trump would want to dismiss it with prejudice, meaning it's dead, done forever, and query whether once his department actually has the case. Can they do that? Can they take a case that's not even on her docket and try to revive it and then dismiss with prejudice? We can talk more about that if you like. But on the dismissal without prejudice, it means it hangs around and at least theoretically could be revived come January 2029, or Smith puts in pungently, whenever Trump leaves office, including by resignation or impeachment, and then revived. And now there could be issues of statute of limitations, more we could talk about as well. But the basic point that he says, this case is good, but weird stuff has happened. Please dismiss it without prejudice. And I think Chutkan will do just that. And Trump will not like that opinion at all.
Before we leave D.C., so you said a couple of things that I find really interesting and a little surprising. The first is, I have always assumed the prosecutor can simply dismiss a case.
Yes.
You're saying the judge writes an opinion? Is this a contested motion? What is the basis?
We'll see, of course, what Trump says. But yeah, it's the judge, it's now on her docket, and it doesn't, even if it's a short opinion, as it normally would be, it's an opinion. Right. It's not enough for the prosecution to just go forward. So that's the first point. What's the second?
The second is so double jeopardy doesn't apply until a jury is sworn in.
That's right.
So there's no dismissal with prejudice required, right? Because there's
That's
no.
right.
Uh, so what would be the basis of requiring a dismissal with prejudice? In other words, that it couldn't be brought up again
Yeah.
if there's if there's no swearing in of the jury. Are there other grounds for that?
Nope, not real. Well, there could be. Now we come to the OLC opinion, which is on two grounds, and
And
we're
OLC
going.
is the Office of Legal Counsel.
I'm
It's a
sorry. Yeah.
division of
So
the
this
Department
was
of Justice.
all a big brouhaha in the Mueller era. The Office of Legal Counsel had opined in '73 and again under Clinton in 2000, written then by a current judge of the same court as Chutkan, saying, "Hey, you know what? You can't prosecute, you can't indict a sitting president." And that opinion gave two main and different kinds of rationales. One was such a terrible, onerous burden on them practically, because you may know the Supreme Court has held unanimously, you can subject them to a civil case. But the argument there was, it's not so much, you sit for a deposition. Well, here, of course, the question would be, and when we come to New York, how onerous would this be? But the second and important point is, in the OLC opinion, there's language, in fact, I'll read it, that there's non-physical yet practical interferences in terms of capacity to govern the president's involved head of the nation. To wound him by a criminal proceeding is to hamstring the operation of the whole governmental apparatus. That, I think, is something he can massage, especially at the U.S. Supreme Court, if it comes to it, and say the whole notion of it remaining somewhere in the cloud and that can be revived, that's the actual constitutional problem. And for that reason, you have to zap it. But to your question, Mark, there's no reason. A prosecutor can and often does dismiss without prejudice, meaning they can bring it back. A witness becomes incapacitated, or they don't want to give up on it permanently, but they realize they can't go forward now. That happens a lot. It will not be to Trump's liking, because he not only wants the prosecutions to go away, he, it's clear, has this sort of obsession with remaking history and characterizing these cases, as he did in his triumphant tweet when Smith a few hours ago filed these motions, that the whole thing was politicized and didn't have merit and the like.
That's DC. Now let's go to
DC.
Florida.
So Mar-a-Lago, remember, was much slower along, and I am going to get in 30 seconds to his possible report, which really matters.
We're going to talk about the report. I'm going to ask you about the report next.
Judge Cannon dismissed that case, saying the Department of Justice, surprise, surprise, every court has said otherwise, doesn't have authority. The statutes they're relying on to say we can have a special counsel don't give them that authority. And that's a really pretty out there opinion, and one that's very vulnerable on appeal. But Smith has dismissed it as to Trump, but not as to his two co-defendants. Remember Walt Nauta and Carlos de Oliveira, the guys who help him and probably at his direction obstruct the whole effort to get the papers back. They're still in the case. And so it's tricky. This is one of dozens of issues we'll have, Mark, where the personal interests of Donald Trump, and which are supposed to be paramount, will really conflict with the institutional interests of the DOJ. The DOJ would like that opinion reversed. It would like to have the possibility of having special counsels, as, by the way, it did with Robert Hur in the Biden case, arguably with David Weiss, and that's the President Biden case, arguably with David Weiss in the Hunter Biden case. They want to get that reversed.
And don't forget the John Durham case.
And the John Durham case, the endless case, right. So there's, if they're really thinking at all when decision-making happens, and this is going to be tricky, the Deputy Attorney General, Emile Beauvais, maybe has to recuse himself because of his involvement in some of this crap. So, but anyway, they decide the smart move, if they care at all about DOJ interests, would be let the 11th Circuit finish their decision, hopefully reverse so that the DOJ has its powers back. And then, and only then, if Trump wants to pardon Nauta and Oliveira and do the full death ray on the case, he can. But they said it's a copycat motion to the 11th Circuit, the Court of Appeals, saying, we like this case, it's still valid.
We'll be right back with more of my conversation with Harry Litman in a moment. Democracy Docket is fiercely independent and unapologetically pro-democracy. It will continue to expose attempts to undermine your right to vote. Support Democracy Docket's growing team of 16 people by becoming a premium member today. I gotta ask you the question that everybody wants to know. So people are coming to terms with the fact that this is going to be dismissed. In some ways, it's not a surprise. People are still angry about it, but everyone wants to know, do they get a report? We've seen these reports come from other special counsel. We saw the Mueller report. We saw Barr's mischaracterization of the Mueller report. We have seen these reports lay out kind of in greater detail what went on. And people want to know, is there going to be a Jack Smith report?
And that's where I was going to go. And it seems to me the answer is yes, and that we will see it. But let's talk about it. He has to give a report to the Attorney General under the RAD.
That's
but
good.
All he has to do is explain his prosecutorial and decisions to indict and not to indict. Now, it's a little anomalous, right, Mark, because he's already indicted, and the indictment might speak for itself, but at a minimum, there's all kinds of uncharged conduct here, crimes and people. He decided not to. And I think he has every justification to really give the sort of full account of the evidence. Arguably, we have it with January 6th somewhat through the January 6th Congressional Committee and Smith's own 185-page motion in the immunity litigation that had started up before Chutkan. But man, there are gaps in what happened in Mar-a-Lago. And for us, like as a democracy today, and certainly for history, which is something Mueller cited in his report, this is our only chance. You've got to imagine if Trump, completely indifferent to institutional interests and completely self-centered, comes in and can just order, to make these into blank pages, he will. So this is really the nation's and history's chance. Trump is arguing, well, the people have decided that we don't want these prosecutions. A, that's bullshit because they didn't decide that. It wasn't that kind of mandate. But B, it's not up to the people, by a 50% vote to say we don't get a historical account for 18 different reasons. As a democracy, we need a historical account. I think that's what Smith is doing in his workshop right now. I think he'll provide it to Garland. Garland has already indicated he'll release it. Now, Trump, from the outside, he doesn't have the power yet. I think we'll try
Can he go to court? Can he go to court to block it?
Somehow, yeah, and maybe appeal and go up to the Supreme Court. I don't see the legal theory that would block it. And for my money, I think the last kind of, final blow, it's small in the overall scheme of things, but important, I would say more than important, indispensable. I think we'll see a report. Remember, the Her case, he gave a 380-page report, saying, among other things, Biden has lost a step. And there was a hearing after that. It's possible we see a hearing now even. There's enough time for it, depending when he does it. So Trump, who knows what he's got up his sleeve to try to block it, and who knows what crazy theory the U.S. Supreme Court might recognize. But I think Smith is right now preparing it. I think it's full-bodied. I think it both goes to the interstices of what he has brought and all the stuff that he hasn't. Watch out, Mark Meadows. Watch out, Rudy Giuliani. Watch out, Jenna Ellis and everyone. And I think there'll be a fight, but that's a fight that I think with the department still in charge under Merrick Garland, they ought to win.
Won't he go to Judge Cannon in Florida and say, look, you've struck this whole thing down, right? You've struck this statute down, therefore enjoin the issuance of a report. Isn't that the obvious play for him legally?
It's interesting. She doesn't have jurisdiction over this case. The whole file has now gone up to the 11th Circuit on
Huh.
appeal. That won't stop her necessarily. And what does the DOJ do if she issues that injunction? It's not clear, by the way. Let's say she's right in her opinion, Mark, and they didn't have authority. He's got apparent authority. He's been appointed. Would the internal DOJ reg be without effect that holds how's she really going to stop? I mean, she can try, but where does she get off telling a lawyer within the DOJ he can't prepare a memo for the attorney general?
Right.
Man, that is a total overreaching opinion. But could Eileen Cannon try that? Could Trump try to ask her? You bet.
Yeah, that does to me seem to be the distinction here, right? Which is that maybe even if the statute was unconstitutional, it meant that Smith wouldn't have to write a report. But if Smith wants to write, as you say, a memo to the person who he reports to one way or the other, like how, what kind of court involvement could there be there?
Right. Talk about a separation of powers problem. She reaches in and says, don't write this memo to your boss. They'll try to reverse that right away. I don't see the Supreme Court making trouble there. But look, they've done. Remember the immunity opinion that was so far reaching because it not only said he's immune, but said evidence can't surface.
Right.
Can they take that principle, extend it, and say we can't have a public report? That would be really friggin' crazy. But so some of these things are imponderables given the institutional chessboard that's lined up against Smith potentially.
All right, so those are the two federal cases, and there are still two state cases. The New York case he has been convicted of, and I think we're in the middle of sentencing, and I'm going to ask you that. And then the Georgia case, which is the big racketeering case, with lots of defendants. I don't even know where that is. So dealer's choice again here, Harry. You want to start north in New York or south in Georgia?
I'm going to Georgia. And I think as a practical matter, it's dead and gone, Mark, but it actually, as a legal matter, it's alive. So what happens? She brings these really large, sprawling RICO charges against 19 different defendants, a lot of capacity to sort of challenge that or question it at the time, but she does. And then you have this, one of the really, you got to say as to Trump, better to be lucky than good or whatever. What a whole series of good luck, political advantage, and then, the American people's final decision. Anyway, this is one of them is that he had the good luck to have a prosecutor who had an affair with the person she'd assigned to try the case, and everything blew up. And there was a motion to recuse her as a result, which the trial court, a pretty good trial court, denied. But he permitted that motion to be appealed. It's gone up to the Georgia Court of Appeal on the question, should Fani Willis's whole office be recused along with Fani Willis? And as I understand the politics of Georgia, which are, ubiquitous, if that happens, would there be another DA to pick up the wounded case? Seems unlikely. But in any event, it hardly matters because the Georgia Court of Appeal issued the most, the biggest kind of stiff arm of all the courts in this case. It issued an opinion last week saying, case is off calendar and we won't tell you, don't call us, we'll call you. They've just suspended it. Obviously, with some eye toward the fact that Trump wins and he's going to be in office January 20th. So we can honestly say, who the hell knows? But as a practical matter, if not a legal matter, I don't see that case ever coming back to life.
Now, how does that case, with respect to Trump, impact or not impact the other defendants? Because as you say, I think there were, you said 17 defendants?
And there's a whole cadre of just Georgia types, but there's also, again, the usual suspects, including, most importantly, Mark Meadows.
This is why I asked.
Who really does, it's as far as I can tell, he really knows everything and we need his knowledge, and he's never provided it, and he's bobbed and weaved pretty successfully, and this was the final spot where it looked like he might have to face the music, and now, maybe not. But, again, state cases. So we start with the point that there's no pardonability from the president. And so it still could come up. He tried really hard to move it to federal court. And by the way, a couple people pleaded here. I'll bet they're kicking themselves.
Yeah.
But anyway, he tried to, but he couldn't. So he's stuck there. And how does it affect? Quite a bit. And let me just do one asterisk here, which is, remember, there are also a few cases involving false electors. You know those very well, in fact.
Arizona, Wisconsin.
Exactly. And, those, in one of them, Trump is an unindicted co-conspirator. So in terms of the whole gang, all the president's men and women here of Meadows, Giuliani, Jenna Ellis, and the like, they're not totally out of the woods. And I don't think he can get them totally out of the woods, whatever they might think. But Georgia, I just see, for independent reasons, a big old mess that is probably not coming back. New York,
New York, our last one. New York, my home state. So tell us about New York.
I was in trial, and a lot of people said, "Oh, it's a chicken shit case," and it's the least grave of the four, but it's bona fide. There's been a lot of cases brought that way. 34 counts, a solid jury conviction, and a judge who during the trial was pretty all business and didn't give Trump too much running room. He himself now seems to be blinking a bit to the circumstances.
So what's the status? He was convicted.
Okay,
what
so
happens
here's
next?
The status. First, he brought a motion already saying, give me a new trial because you let in some evidence that you shouldn't have under the Supreme Court immunity case. That's pending. Then, in addition, he wants to do this big immunity case that's going to say, kind of consistent with what I was just saying about the OLC opinion, one, I can't be made to show up for sentencing. That in and of itself is a violation of the separation of powers, forcing me to show up at all. And there's some language, at least in the OLC opinion, that you might take in support of that. And two, I can't, for separate, abstract constitutional reasons, have this hanging over my head. How am I to deal with New York when it has this leverage on me and the shame in the international community? But of course, that's that's the shame that he already did. He comes into office as a felon and a convict. Now, the actual state of play is the DA has said, and the judge has agreed, okay, something unusual has happened here. Let him bring his big motion first. And everybody understands, if by chance Merchan, I shouldn't say by chance, if by reasoning Merchan says, okay, you win, the whole case should go away, then there is no sentencing. I think that's a lousy motion. And I don't think there's really any constitutional basis for his saying that. But right away, what will happen if he denies it? Appeal to the the middle level court in New York, the highest level, and then potentially the U.S. Supreme Court. And it would be only slightly crazier than the crazy immunity opinion for them to say, yes, just the existence of this is a problem. But I want to make one thing clear. A lot of people have been under the misimpression that Merchan has said, see, in 2029, I realize it's a problem. He hasn't said that. What he said is, I'm going to decide this big motion of Trump's first. If I deny it, we know he's going to go through his appeals. We know that will take some time. But then, like 2026 and not 2029, sentencing will be ripe. And, there's then that argument will be set up that kind of goes right to the sort of bifurcation I was talking about in the OLC opinion, which, don't get me wrong, is not law. But Trump will say on the one hand, oh, it's such an onerous burden. Come on, it's just showing up for one proceeding. But he'll also say it's such a philosophical or a political burden to be subject to this, and we'll see what the courts do with it then. But it's a state case. There's one other stratagem people talk about. Well, it wouldn't work anyway. Well, let me just tie up one little loose knot. Could he maybe pardon himself in the federal case if it still stays along? And I think the answer to that is no, but we would see. So the New York case survives. It has the possibility of, a jail sentence. Cases that like them, in which defendants like Trump here have behaved like jackasses. He, violated 10 gag orders. He's never had any, he's been nothing, no contrition at all. You could see his getting a short sentence and the, jail door swinging open January 20th, 2029. You could also see Mayor Chun doing something like this, sentencing him before 2029 if Trump can't prevent it, but maybe give him a fine or something like that. That'll effectively make the whole thing go.
Yeah. What is the in other aspects of the law, there are statute of limitations, and there's a doctrine called latches, which is essentially, even if you didn't make a statute of limitations, you just waited too long. Is there an equivalent of that with respect to sentencing? I mean, at some point, could Trump say, look, it's just like you waited so, like, I can't be sentenced. This thing can't stretch out over time because that denies me, I don't know what, but it denies me.
Yeah. The short answer is no. There have been plenty of sentences. For example, Mark, plenty of times somebody has to cooperate with the government and they got to go through the whole thing. It can be years, more than 4 years.
So there's no speedy sentence right.
That's correct. Not only that, but the general idea, evidence gets old, whatever.
Right.
No, that's been dispensed with. So no legal or constitutional problems. So it could happen. You just get the feel, right, that in New York, it's the last outpost. It's not that big an opinion case. He's pawn the stall to maybe personally go after Alvin Bragg, or relatedly the AG, Letitia James, who's brought a big civil suit. Just a lot can happen between now and pronouncement of sentence, and between pronouncement of sentence and execution of sentence. But legally speaking, it's a live possibility that I don't see Trump being able legally to extinguish, that he do a little bit of time in Rikers Island on this.
Yeah. Okay. So a couple of macro questions now, just looking back over the course of the last few years. It feels like Donald Trump gamed the system and won. And so there are a couple of ways, I think, to see that. One is, like you said, better to be lucky than good. And that, that's just the way it is.
Yeah.
The other is to find fault. And, some people are blaming Merrick Garland, saying he didn't move fast enough. Some people are blaming the various judges. How do you make sense of all this? Is it just like that's sometimes weird shit happens, or is there a bad guy, or is there a decision that you look back on and say, you know what, really, this is why we wound up where we are?
I'm the first. I mean, sometimes no. Once in the life of the Republic, a tsunami combines with a tornado, combines with a, explosion. What an incredible concatenation of circumstances have even delivered him, who did clearly, in the sight of the whole country, the most treacherous act against the Constitution, our political history, have delivered him again to the presidency. So to, look back on 2020, all the people, sage people, who said, well, okay, at least we're done with Donald Trump now and he won't be a factor. So I think he gamed the system, but he talk about drawing to an inside straight, or hitting 7-8 times in a row. He placed this huge long odds bet, although he had some control over it, and he won. That's how I see it. And let me talk specifically to Garland. I'm going to say something.
That's the big one, right? That's
the
question.
Would be the big one. Could Garland have made it happen? I'm going to state an unpopular opinion. I just want to state at the outset, a lot of people disagree with me. Have them on your show next week. But I have a sense of what was going on in the department during the time that people were screaming, you should be doing this. And they were advancing the ball, even if it wasn't public. I also think there's just no way practically, and it wouldn't have been responsible to come in March indict the president of 4 months ago. And I also think, given all the kind of crazy weather, especially the U.S. Supreme Court, if you get out your counterfactual calendar and you draw on it, they don't get to the, with Cannon, with the Supreme Court immunity opinion, you don't get there anyway. So I do not fault Garland, and I think he was on it. He obviously was on the crime. It was the biggest prosecution in DOJ history of the actual assault, January 6th. I'll just tell you that I've been in the minority on this, although, including among people who have, we're also former prosecutors for a long time. But I think you can't lay the blame at Garland's.
All right. You are a former prosecutor.
Yes.
And the other
and
big
a former colleague. I worked down the hall from Merrick Garland, who I do think walks on water. So that's part of it.
People right now are rightly, or maybe you'll say wrongly, concerned that the Department of Justice is going to be the arm of Donald Trump, that he will use it to settle political scores. He will use it to prosecute his enemies. He will use it to, make all kinds of mischief. You are aware of those concerns, but you're also, as someone who has worked in the department, aware of the checks and balances, the guardrails that are there. So how should people think about what Donald Trump can do, what pushback there would be, whether it's Pam Bondi as the Attorney General or it's someone else? Like, how concerned should people be about the Department of Justice being weaponized against political opponents?
They should be, as I am, frigging terrified.
Huh.
This is an absolute priority of his. He wants to mow down and weaken no agency as much as the DOJ.
Right.
He is committed, as is his government already, to a view that would take us back to the 19th century sort of spoil system of what the president says goes. Look what's already been reported that the plans are in motion to do. Go after the career attorneys who are the heart and soul of the department because they happened to do their job right and be on Jack Smith's team. Get a whole squad together to look for the real killers, find evidence of 2020 fraud, and put attorneys in the position of having to make statements that aren't true to courts. Otherwise, have loyalty to him personally, be the organizing principle of the DOJ, and wherever Bondi is, even if she or Emile Beauvais, who came from the from the SDNY, so you might think has some professional chops here, the absolute constitutional basis that no one's going to be able to deny or they'll get sacked right away is that he has this power to mess around with anything and anyone he wants. And just the start, if all he did is fire, really go after as a matter of reprisals, the DOJ attorneys who worked on his cases, and the 99% else of the DOJ worked as it's supposed to. They didn't make a priority of the Comstock Act. They didn't weaken the Civil Rights Division. It's still a giant step toward autocracy. I mean, I've been,
are there no guardrails internally to prevent this?
Sure there are, but under his theory of the presidency, the first thing he does is take the snow plow and just plow him out of the way. If he has the constant, we're talking about constitutional norms that have been super important since Watergate. But if the DOJ and the U.S. Supreme Court accepts the view that whatever he says goes, bye-bye norms, bye-bye guardrails, everything collapses and he does whatever the hell he wants. And there's reason to think, right? When shit like that happens, you think, okay, but once he governs, smarter heads will prevail. No. I don't see it so far. The evidence of the first 2 weeks, to me, are that he's every bit as crazy and focused like a laser on DOJ in particular. People there are terrified. There's already a sort of exodus. And what he's talking about is the total erasure of norms that, are cultural and are built up over generations you can't just in 2029 re-erect. I am, people tell me, keep your chin up, try to be constructive. The job as I see it now is using for me, this is, just started a Substack with this kind of in mind,
Uh,
is using the knowledge and experience I have to actually detail, is this, democracy's decline, are we potentially one of them?
uh,
As I
all
see
right.
it, you bet we are.
All right. So here's in the last few minutes we have remaining,
Yeah.
you are, in addition to being an accomplished lawyer, in addition to being a former prosecutor, you are also quite an accomplished media presence. You have been a columnist at one of the largest newspapers in the country. You have a very, very popular podcast, Talking Feds,
Yeah.
which is both on the normal podcast but also on YouTube. You recently started a Substack, and I
Yeah.
want you to tell me a little bit about that. But
Well,
but
that,
before
yeah.
but before you, or in the context of doing it, there has been an enormous amount of churn and consternation about the media. And the growth of things like Substack. I'm sure you see in your own podcast and in your own YouTube how it has grown and how it is now a huge force. I mean, you reach as many people in your just on YouTube in your episodes as a mid-size publication will all their readers. And in many of your episodes, I checked where you're reaching more people than some of the cable networks reach in their prime time. So how do you think about the role of media, traditional legacy media, new media, and how does that interplay with your decision to both expand your audio and visual offerings, but also start a Substack?
Yeah, so thanks for that, and it's all true. And look, going forward, I purposely am not with any one cable station, so you can do different
Right.
ones.
Me
But
too. Yeah.
man, oh man, the CNN, which I did this morning, I think it's average, or maybe it's MSNBC. Its average viewer age is 70. Everybody I know gets their who are 40 and below,
Right.
gets news first on YouTube. Legacy media is in an awful tough spot, not to mention the whole huge problem, the Michael Tomasky article in the New Republic of the
Yep.
closed right-wing ecosystem and the people who vote for Trump not hearing the facts. But it's true that I have this agreement. But I would add one thing, maybe as important. I was sort of middle level senior DOJ official, but I know DOJ culture, and that's even more important. So now he was making these broad arguments during the campaign that he was shouting out the trouble he could do. Now he's going to have the levers of power. And to be able to explain why something like going after career employees or employing the military to do deportations, or the different kind of specific moves clothed in legal garb, which, by the way, is what happened in Hungary, what happened in Russia. I do think the best use of my experience and whatever writing chops I have is to try to explain that, even if it makes me kind of a glum Gus, but to say these risks are real. There's historical precedent for them. Listen to what he's saying and what he's doing. We're talking real assault on the constitutional rule of law. So yeah, the best thing I think I can do to bring that home, you can't say that in a quick hit on TV. You can't say that, except necessarily in a column, but 3 times a week in a Substack, kind of going through, look, everyone, this looks like a little too complicated to understand. It's not. And when you really look at it, we're talking a real erosion of rule of law and constitutional norms. That's what I'm trying to do with the Substack.
Well, first I was a longtime listener to your podcast. Then I made the switch to YouTube, and I love watching your YouTube. I actually, I feel like, the election is all about podcasts, and I've kind of moved to focusing more on YouTube, consuming more on YouTube. But I love your show on YouTube. We
Thank
will
you so
put
much.
link. You just interviewed Senator Murphy, I saw, which was a great
Yeah,
interview.
man, he was
Um,
great.
yeah,
Yeah.
and so we'll put links to both of those in the show notes. But what
Oh,
is the
great.
name of your Substack so that we can link to it? But also, I want to make sure people go right now and subscribe.
You're the best. It's really hard. Are you ready? Talking Fed Substack. There you go.
There you go. Make sure you do that. Also, I saw that you are now on Blue Sky,
Yeah,
which
you
is a
got to
new
tell me, Mark, what's your secret? Why are you almost at 500,000? What did you do that I'm at a paltry 100,000?
I'll tell you,
Yeah.
some of life is just timing. I happen to be on it at the right time, I think,
Right. Half of life is
as I say,
showing up. Is that the Woody Allen
yeah,
line? Yeah.
exactly.
Right.
But you are definitely worth following. I follow you on Blue Sky. I don't follow a lot
Thank
of
you.
people, but I follow you. Make
Yeah.
sure you are following Harry on Blue Sky. I'm not going to tell you to follow him on the other place because everybody needs to get off the other
Yeah.
place, but follow him on Blue Sky. Harry, thank you for joining us today.
Mark, you're one of the good guys. Look forward to talking to you over these 214 weeks left.
You got it. Thanks.
Bye bye.
Thanks for listening to this episode of Defending Democracy. Please support Democracy Docket by subscribing to our free daily and weekly newsletters or by becoming a paying member today. Links are in the show notes below. We'll see you next time. Defending Democracy is a production of Democracy Docket LLC.